YouTube with the deal is. Now I'm back at it. But got something for y'all, man. Court appearance. Darrell Brooks. You feel me? If people not familiar with him, get familiar. Cause this trial gonna be the trial of the fucking century. I'm telling you. But sovereign citizens, man. Do y'all know what that is? So from my basic knowledge and understanding of it, it's people who don't feel like they have to abide by the rules of the United States, because they're saying basically that they're their own state and the United States can't own them. I could be wrong, but that's my basic interpretation of it. So this is the thing for people that don't know. This is the thing. My bad, I was cooking. I had grease on my hands. But yeah, this is the thing for people who don't know. You know, and let me show y'all a couple instances of what these people do.
But we told you he's an Article 4 free inhabitant, so he does not have to have a license. This is on recording. Article 4, free inhabitant, pursuant to the Articles of Confederation. You can look it up. It's in the United States Book of Codes. It is your laws you have to follow.
All right, I will do that. Just be smart. So I'll walk you back here.
Article 4, free inhabitant, pursuant to the Articles of Confederation.
Put the camera down for me. Is that if it records, that's fine. But I don't want you holding anything.
No weapons, no weapons. All right, no.
Okay. So what I'm going to ask you to do is the same thing.
And get out of the car?
Yes.
No, I'm not getting out of the car.
All
you can go get your superior.
Well, I am going to tow this car, and you cannot be in the vehicle while I'm towing this vehicle.
Well, if you go get your superior, he'll clarify
right
that he can be set free because he does not have to have a license.
That's not going to happen right now, young lady. So either you're going to come out of the car on your own free will, or I'm going to assist you.
I'm going to get out of the car and walk down to that house.
No, you are not free to leave right now.
Are you saying you have authority over me?
Yes, I do.
You have proven authority over me?
Yes, I do.
How did you do that?
The County of Imperial through the sheriff.
You do not have authority over a human being, over a free inhabitant.
Do you want to argue the point?
You need to go look up your laws.
I don't have to look at anything right now. What I need to do is get you out of the vehicle. If you have identification, please hand the identification over to me.
No.
Identify yourself to me.
And I'm not going to step out of the vehicle.
All right. Well, you know, you are impeding my investigation. You are delaying me, which is a penal code violation in the state of California.
That law only applies to U.S. citizens.
Well, where are you a citizen of?
I am not a U.S. citizen.
Well, see, that's
I am a free inhabitant. I am of the earth. I do not belong to any corporation. I do not belong to any country.
Yeah, but as long as you're in the...
Name, rank, and bear's number, please.
I'm Officer Tim Edwards with the Austin Police Department. I need to see your...
Do you have a warrant?
No, I have you for speeding.
That's not a crime. You don't have a
registration.
You don't have a warrant to search my private person.
You don't have a valid license here, sir.
So you trying to force a contract on me, which I'm not obligated to perform under that contract. You trying to force a contract on me. Do you have a victim? Have I committed a crime?
Citizens of this city, sir.
I'm not a citizen. I am a national, a sovereign. Not a sovereign citizen, none of that. I am a sovereign Hebrew Israelite American national. I am not a citizen. I'm of the Tennessee Republic, not the state of Tennessee, which is a corporation, and you are a private contractor for the state of Tennessee.
He said we were speeding, but
I have no obligation to perform under the contracts that you're trying to force on me right now. You're violating my constitutional rights, which you took an oath to uphold.
All right, so you see them two police confrontations, right? We don't know how they ended up. How they ended up ain't even important for this video. But you see the resistance they put up. Like, these people really believe that they don't have to abide by the rules. You know, like, no tags on the cars, no licenses. They can just drive where they want. They can just do what they want. Like, this really, and it's like, even in 2022, people still believe this. But we got the situation, the case of Darrell Brooks. So right now, Darrell Brooks is in pretrial. And I'm going to get into what Darrell Brooks did. But he's in pretrial. I think trial was scheduled for another couple of weeks. But he had this confrontation with the judge. And it's epic. Check it out.
As a sovereign citizen. So essentially, this matter today would be me appearing by special appearance.
You have an absolute right to have an attorney represent you. It is protected not only by the Wisconsin Constitution, but the United States Constitution. Do you understand that?
I do understand my rights under the United States Constitution, yes.
All right, before I get too far in it, you got a basic understanding of what's ready to go down. You feel me? It's gonna be a lot of back and forth, a lot of combating. Now, Darrell Brooks not just no anybody. He ain't locked up for no bullshit, no minor charges. You feel me? This is what Darrell Brooks did.
We are also on top of breaking news out of Wisconsin. This is where an SUV plowed through a Christmas parade.
Yeah, now at least 5 people are dead, 48 injured, including 18 children. We're also learning more about the person of interest taken into custody today.
And Madeline Rivera, she's live in Wisconsin now with the very latest for us. Madeline.
Good afternoon, Bob and Marla. And a lot of people had been looking forward to that event, but within minutes, that event turned into tragedy as a man plowed down the street behind me, hitting dozens. Now we're learning more about the man behind the wheel. Minutes ago, Waukesha police identified that man as 39-year-old Darrell Brooks. He is now facing 5 counts of first-degree intentional homicide. Moments before he barreled through the parade, authorities say he had been involved in a domestic disturbance, emphasizing that this was not a terrorist event. 18 children were taken to Children's Wisconsin Hospital for injuries ranging from facial abrasions to broken bones to serious head injuries. 10 were taken to the pediatric intensive care unit. 6 are in critical condition, 3 are in serious condition, and 1 is in fair condition. Among the dead are members of the Milwaukee Dancing Grannies, the organization saying in part, quote, "Those who died were extremely passionate grannies. They were the glue, held us together."
So people probably remember this instance, because I do, but didn't know his name or maybe forgot about it. But he plowed through a whole group of people marching, a marching band, children and all, fucked up. You feel me? So, like you see what he trying to claim. He trying to claim he's a sovereign citizen and he don't gotta abide by the, he can do what he want. You know what I mean? No holds barred. You feel me? Rules are made to be broken. You know what I mean? But check out this back and forth he having with the judge.
Did you hear what I said?
Repeat it.
Do you understand that you have the right to have an attorney represent you, what we call the right to counsel?
Under the 6th Amendment, correct?
Under the 6th Amendment, the 14th Amendment, and the Wisconsin Constitution as well. It's a well-established right that a criminal defendant has. Do you understand that?
I'm aware, yes.
Okay.
I would like to represent myself pro per.
What does that mean to you, sir? Do you understand, sir, that you can't have an attorney and exercise that right and also exercise the right of self-representation?
No, I don't understand that.
So you started off this hearing by saying you want to exercise this right to appear in persona today and act as a sovereign citizen. Sir, my concern here today is there's a request from your attorneys to withdraw from this case. Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are.
I'm aware of it.
My question is, do you understand?
I'm aware.
Do you understand what it says, sir? Do you also understand that you have the right to represent yourself?
I'm aware of that as well.
I have before me a motion to withdraw by your attorneys with the sole basis that is listed that you want to represent yourself. Is that your understanding as well?
That isn't entirely how the issue came about. I think it's important for that to be on record.
I'm not asking you to divulge attorney-client privileged information. Do you understand that?
So essentially, what is the question?
Well, I want to make sure you understand you have these competing rights. It is recognized in our case law from the United States Supreme Court, the Wisconsin Supreme Court, that there are these competing rights: the right to counsel and the right to self-representation, essentially to be your own counsel. Do you understand these competing rights?
I am aware.
You understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case, and I credit them with that. I'm appreciative of that. But it also should be said that there's a lot of things that I did not understand.
If I allow them to withdraw, you lose their legal experience, their specialized training, right? Their education, their work as attorneys. Do you understand that?
No, I did not understand.
So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What, other than you are accused of 77 counts, which I will go through momentarily, any physical or psychological disability that would affect your ability to understand the paperwork that's given to you in this case?
Not paperwork wise, no.
Any physical or psychological disability that you believe would affect your ability to communicate in the courtroom, whether to me or in front of a jury?
Absolutely not. I'm doing a good job now.
Do you know at what grade level you read? Do you believe it's a high school educational level, a college level?
I don't know. I wouldn't be able to guess that off the top of my head, but I'm pretty sure that is adequate.
Are you able to hear me right now?
Yeah, I can hear.
Did you hear me advise you about the penalties for hit and run resulting in death?
I don't understand the nature and cause of the charges.
Again, sir, did you hear me right now?
I heard you right now, yeah.
Did you hear me tell you the penalties? Yes or no?
Yeah, I heard.
If you understand. Sir, you're the one who wants to represent yourself in this case, so I need to go through all of the penalties with you. There are 2 counts of felony bail jumping. Each one of those counts is a Class H felony, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 6 years or both. Did you hear me tell you these penalties just now?
I don't understand them.
Did you hear me?
I heard you.
There are also 2 counts of misdemeanor battery domestic abuse. Each one of these offenses is a Class A misdemeanor, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both. And because each of these charges is an act of domestic abuse, costs upon conviction would include the domestic abuse assessment imposed under Wisconsin law. Do you understand, sir, what I have just told you about the penalties for misdemeanor battery?
No, I do not.
Did you hear me?
Yeah, I heard you.
For the first-degree recklessly endangering safety charges, if I were to calculate all of the imprisonment that you face from a maximum standpoint, it would be 762.5 years plus an additional 305 years for the enhancers for use of a dangerous weapon. You understand that?
No.
Did you hear me just now recite that though?
Yeah, I heard you.
For the 6 charges of hit and run, the maximum exposure that you face for just those 6 offenses alone is 150 years. Do you understand that?
No.
Did you hear me say that though?
Yes.
For the 2 counts of felony bail jumping, the maximum for both offenses is 12 years imprisonment. Do you understand that?
No.
Did you hear me say that though?
Yes.
For the 2 Class A misdemeanors, the maximum is 18 months, meaning 9 months plus 9 months. Do you understand that?
No.
But did you hear me say that?
Yeah, I heard you.
You heard me advise you of all of these penalties. Is that right, sir?
Yes, I heard you.
A competent defendant has a constitutional right to represent himself, even if the judge or anyone else thinks there may be no good reason for him to do so. I'm not saying you don't have a reason, sir. I'm frankly speaking to your mom at this point. She may not understand. Frankly, her understanding is not material. You have the constitutional right to make this choice. What's important for this court, and why I also went through some of the other biographical information, is you have a high school education. You've completed the 11th grade. You have an HSED. You are clearly literate. You've been able to communicate with the court efficiently and effectively. At times, you press the court when there is something you don't understand or believe is not going your way. But to me, that's a sign that you understand and are advocating on your behalf. Frankly, statements like I'm informed or I'm aware are the functional equivalent of you saying I understand. I cannot say that this is one of those narrow class of Mr. Brooks.
I object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't
that's
interrupt.
the
I
procedure
interjected.
that we will
Objected.
follow. At trial, what's going to happen if you continue to do that is you will be admonished in front of the jury.
That's fine.
If you continue that.
That's fine.
Like I said, this is not one of the narrow class of cases in which a defendant may not be competent to represent himself, because there's no evidence before the court to suggest he has a severe mental illness, which is why, of course, I looked at the NGI evaluations, because that is competent, recent information before this court regarding his mental status and his understanding of what is going on.
That has no relevancy to
this
why
court
we're here
is then
today.
able to
Do not understand, but I heard you.
Sir, do you want to be represented by a lawyer in this case?
No, I do not.
Do you understand that you have a constitutional right to be represented by a lawyer in this case?
I'm aware that that is one of my rights under the Constitution, yes.
You understand that if you do not have enough money to hire your own lawyer, you may be entitled to have a lawyer appointed to represent you. Do you understand that?
I'm aware, yes.
I also need you to understand that the trial will continue under the same legal rules that would apply if you had a lawyer. If you represent yourself, you will have to follow these rules. Because you are not trained in the law, this will make it hard for you to challenge the evidence presented by the state, and hard for you to present any evidence that you want to present. If you decide to testify, you will be sworn as a witness and can give testimony while you are acting as a witness. You will be asked questions by the other side at that time. However, you cannot try to testify while acting as your own lawyer. Do you understand these things, sir?
No, I don't, because it sounds like pro se to me.
Because it sounds like what?
Sounds like pro se to me.
Well, there are two options here. Pro se means you act as your own attorney. You're self-represented. So when I talk about not having a lawyer, representing yourself, acting pro se, those are all the same. They all have the same meaning. Do you understand that?
No, I do not. My understanding that it's not the same meaning as representing yourself as pro per. And if that could be clarified for me, then it would greatly help.
Under the Constitution, you have a right to have a lawyer and you have a right to self-representation. Those are the only two rights that I am talking about today.
I'm aware of that.
So whatever your understanding about some other hybrid fashion is not what I would be proceeding under. Do you understand that?
No, I do not.
What is your expectation, sir, about proceeding on your own in this case, in this pro forma, as you have said?
I simply seek to represent myself pro per so that I can establish my sovereign citizenship.
But what does that mean as to whether you have an attorney or not to you?
Clarify what you're saying, what you're asking.
You keep repeating this phrase, is it perf? Spell it for me.
Yes,
I want to
pro per,
make sure
yes.
that I have the right words that you're using.
You want me to spell proprietary persona or pro per? Which one?
Tell me what you think you want to do in this case and what phrase or term that you're using and what it means to you.
Your Honor, I just stated on the record what I would like to do. I don't think.
Spell it for me.
PROPRIAPERSONA.
All right.
Well, my understanding is, I don't see how that comes into play. That's why I'm asking, is it a way that can be, that part of what you're saying, just that part can be clarified to me, because that was not my understanding, that there had to be some waiver of rights and things
Sir,
of that
in
nature.
order for you to represent yourself, you need to waive your right to counsel in this case. Do you understand that?
No, I do not, because it's not clear to me. Is that a
You
way?
can't have it both ways, sir. You
I'm
either
not trying to have it both ways.
listen to
I'm
me.
just asking.
You either have an attorney and you're exercising your right to have an attorney, or you waive your right to an attorney and you act as your own attorney, what I refer to as self-representation. Doesn't matter to me what phrase you put on it. The Constitution guarantees you the right to have counsel, and it guarantees you the right to represent yourself. In order for me to honor your request to represent yourself and allow that in this case, means you must waive your right to an attorney.
Now, since you just broke it down that way, it's a little bit more clear. That's all I was asking.
I don't necessarily know, right, what's going on in your mind. That's why I ask a lot of questions. So do you now understand that, sir?
Yeah, I would like to waive that right to counsel. I would like to represent myself from her, as I stated, yes. That the state of Wisconsin is the injured party. How could the state be an injured party?
Sir, I am not going to go down this path of giving you legal advice. Are you?
I'm not asking for legal advice.
Right, and I don't need
I'm
to
saying I'm
provide.
confused on how that can be. That's what I'm saying.
Well, the bottom line, sir, is the state of Wisconsin is the legal entity represented by the Waukesha County District Attorney's Office that brings charges against a defendant.
Alleged defendant.
Well, no, you're a defendant accused of committing offenses. You're not an alleged defendant. You are a defendant, but the allegations are accusations. Are you aware of that?
No.
Are you now aware of it because I just told you it?
No.
Making a deliberate choice today to waive his right to an attorney and proceed without counsel. This court further finds that Mr. Brooks is competent to proceed, whether he refers to that pro per, pro se, or simply self-represented. He reads, he writes, he understands the English language. He's been able to communicate with the court. He has no physical or psychological disability that impacts his ability to communicate with the court or to communicate a defense to the jury on his behalf. I've not been able to find on the record, and he has not advised the court of any disability, physical or psychological or otherwise, that would affect his ability to communicate with the court or to a jury. In the words of Pickens, Mr. Brooks has the minimal competence necessary to conduct his own defense.
Yeah, I don't know how the judge is, like, she's doing a great job. And not a bad looking judge, by the way, either. You feel me? But she's doing a great job keeping her composure. You know what I mean? Like, I take my hat off to certain people during certain times, man, because I laugh. I'm sorry. I know she gotta remain professional, but I would laugh because he know what's going on. But for some reason, in his world, in his mind, he think that he's in the right. And he think he's actually gaining traction on what he's trying to do. Now, if I can guess, I would think he's probably trying to go for a mistrial. You feel me? But the judge is doing a good job of making sure he understands. Even though he keeps saying he's aware. She's making sure he understands what he's doing. You feel me? So he's trying to get rid of his attorney. So that's why I say this trial is going to be epic. Because the judge let him do it.
Statutory provision and a constitutional provision regarding the right of a victim to attend all proceedings, including trial. And there's a clear language in the statute in 906.15 that says the presence of a victim during the testimony of other witnesses may not itself be a basis for a finding that exclusion of the victim is necessary to provide a fair trial for the defendant. For Spanish interpreter, Mr. Brooks, you should be aware that during the meeting I held with the attorneys yesterday in my jury room, which you were not present at, I advised the state that there's a state form regarding the use of interpreters, that I needed the state to fill that form out as to each request being made, because that form will assist the court in appropriately scheduling the interpreters, or could be one, could be more than one, because part of that form is to tell me what day and what time the interpreter is needed. And so it's my understanding the state's going to work on that. I have an obligation under the law to provide interpreter services for the parties, if need be, for victims, for witnesses. And so I am working on that. Any questions about that?
Yes, it says right here that those victims will potentially testify. Would the testimony then be in Spanish?
We would have an interpreter and the testimony would be interpreted. And so both of the answers in Spanish and the interpreter would be placed on the record. That's the purpose of an interpreter.
So there would be a counterpart to that in English so that I would know exactly what's being said?
That's what the interpreter would do.
Right, but how would I
can't answer that, sir. The interpreter will assist the court, the jury, and the parties to understand the answers that are provided.
Yeah, that's all I'm asking. I just want everything to be exact, because a lot of these victims have heard a lot of, if probably not the majority of everybody's story. I do agree with the fact that you make that very clear that it is public. They certainly should have a right to be here. And you also made it clear that there is a live stream available as well. You also made it clear that everybody is not going to be able to fit in the courtroom, no matter how much they want to attend the trial or not. The live stream is available for them. I just think I wouldn't go as far as to say it will be confusing to the jury, but it would be issues, I believe. What if some of these witnesses are some of the witnesses that gave statements, and something that comes up in somebody else's testimony might not spark something in them and say, oh, I forgot to say that. And then now that becomes a discussion, which I don't think anybody would not have had a discussion amongst themselves about what they have heard to this point and what they will hear. I'm quite sure there'll be a lot of breaks during the trial. I think it would virtually be impossible for somebody not to have a statement, or to make a statement, or for somebody to overhear something that may want to be brought to the attention of the state, or victim advocate, or something like that, that may find its way into testimony that probably wouldn't have been there from the beginning. So I think I would agree with, when they were my attorneys, with what they filed.
So do you agree or disagree with the request from the state?
I disagree. Sometimes in Spanish, some words are kind of pronounced different. They mean certain things in English. So I just want to make sure that everything that's said in Spanish will be interpreted correctly in English.
That is why we have an interpreter. All right.
Place at the wrong time to witness this, not through any choice of their own, but by subpoena of the state, are going to be asked to come here and relive this horrific event. So that's what we base the request on, Your Honor, to respect their privacy, not as a victim, but as a witness.
Is there any case law on this issue, at least the SCR 61.11?
I
that
could
you're aware of?
find no case law, Your Honor. This is the only authority I could find.
Mr. Brooks, do you have any position on the request?
I do. I think that if those particular witnesses have expressed the emotional strain that they would go through by having to come to court and relive seeing the videos, or just hearing certain testimony and things like that, it would probably make sense to just remove them from the list altogether. That will cut down on the amount of time spent during the trial, because I'm quite sure there are going to be some long days and some not so long days, but I think why not just remove those people altogether to limit the time, and save those people from having to go through that if they've already expressed not wanting to do it in the first place. And as far as I do understand what the state's position on certain people not wanting to be shown their face, not to be filmed. That's understandable, and a lot of what they're saying I agree with. But what I don't agree with is the time that we live in right now, with pretty much everything is at our fingertips, whether by Google, whether by social media, or different types of things like that. It wouldn't be that difficult for just the name to be solved, and then somebody somewhere might want to just Google that name and find out information about that particular witness. So I don't think either way is really protecting them from anything. I think if they choose to be a witness in this case, they're pretty much, the public is going to know who they are. So I would think it would be more logical to just remove them off the list altogether.
The issue of removing people from a witness list is not before the court, Mr. Brooks. The issue is limited to whether I will allow the images of the witnesses to be broadcast on the live stream or by the media. Of course, any witness who testifies in this case will have to do so from the witness stand, which is to my right. This is a public trial. Anyone could come in and see the witnesses, listen to their testimony. All witnesses identify themselves. I think you make a interesting argument about the social media and access to information about people in general. It's pretty astute, Mr. Brooks, because what I don't have on the record before me is really the ability to make a for-cause determination, with perhaps one exception. And that would be for juveniles who are minors. I think juveniles and people under the age of 18 have some added protections. Of course, all victims have the right to privacy under the statute and under the Wisconsin Constitution, but I need to balance all of that with the right to a fair trial, the right of the public to be present, the right of the media, right, the right of the press to cover this trial. I think I balance that with the fact that Mr. Brooks's images and the images of the parties have been on media on sometimes a daily basis. There's been no limitation on what images of him have been put out. This court has been live streaming the proceedings from the beginning. There's a practical consideration.
Yo, if y'all don't watch this trial, you're going to be missing something you might not see again. For real. It's going to be a lot of back and forth during this trial. Remember, he representing himself now. He ain't got no attorney. So it's just him versus the judge versus the prosecutors versus the witnesses. Man, this is going to be crazy. I want to know who he got it. I mean, what's his defense? Do he got somebody to call up? Do he got witnesses that's going to come up there and speak for him? Or is it just going to be him talking the whole trial? This must-see television. Flat out. This is must-see television. The man asked the judge, why do the witnesses need to be there? We need to just get rid of them. Just get rid of them. Yo, the man said just get rid of the witnesses. Flat out. Like, what we need them for? We can continue the trial without them. They are the trial. There's no trial without witnesses. And he know that. That's why it's so funny. But in all reality, this case is really serious. Like, you heard, the man facing 77 counts. He's facing like 560. The years is, I don't think you put a number on the years he's facing. But it just amazed me that he really going in court with this sovereign citizen garbage. Because that's what it is. This shit, it don't work. Like, I don't even know why people try that shit. The first time I seen somebody do it, and I think this is probably when everybody's seen it, is around the time when YouTube first started up, the internet was just cranking. And there was a black dude on there, he got pulled over. I was trying to find that video, but I couldn't find it. But he got pulled over, and the police let him go. So it appeared like, oh shit, that shit worked. You feel me? And I think that's where a lot of people latched on to it, but ain't no telling who that guy was. If anybody know who that guy is, tell him we need to talk. Flat out, because I need to know what the motive was to that video, because whatever he had going on at that particular time don't apply now. And I'm not even sure it applied back then. You feel me? But let me know how y'all feel about this, man. Is y'all tuning in to the trial? Do y'all think the judge is going to be able to keep her cool? Not guilty or guilty? What's up? And if he get found guilty, most likely, because that's what's going to happen. How much time you think he deserves, man? I think he deserves time just for playing with them people. Ain't got nothing to do with the charges. Sentence him for playing first. But let me know how y'all feel about this in the comments, man. Make sure y'all subscribe, support the movement. I'm out of here.